Fraud in the factum occurs when someone is deceived into signing a document without understanding it's actually a contract. This serious legal issue can void agreements and lead to significant damages. Today we're examining what constitutes fraud in the factum, how it differs from other types of fraud, and what legal remedies are available. Fraud in the factum is fundamentally different from fraud in the inducement. With fraud in the factum, a person signs a document without realizing it's a contract or without understanding its content due to deception. This serves as a legal defense that can completely void a contract. In contrast, fraud in the inducement happens when someone understands they're signing a contract, but does so based on false information. This is considered an equitable defense and can result in contract rescission. The word factum comes from Latin, meaning done or doing. Fraud in the factum involves the deliberate concealment or non-disclosure of existing facts, causing someone to enter an agreement without all relevant information. An example might be when a signature is forged on a previously agreed contract, or when terms are altered without informing the other party. To establish fraud, 5 key elements must be present. First, there must be misrepresentation, typically a false statement or concealment of facts. Second, this misrepresentation must be material to the contract, meaning it influenced the decision to enter the agreement. Third, there must be intent to procure a contract through deception. Fourth, the victim must have justifiably relied on the misrepresentation. Finally, there must be demonstrable damage or detriment resulting from the fraud. Courts have specific criteria when evaluating fraud in the factum cases. They examine the sophistication level of the allegedly defrauded party, whether there was clear intent to deceive, any misleading statements or concealment of the document's true nature, and proof that the fraud caused measurable harm. The landmark case United States v. Baldwin established that fraud in the factum invalidates contractual obligations, making them unenforceable. When defending against fraud claims, several strategies may be employed. A defendant might argue there was no misrepresentation and that the document was properly disclosed. They could claim the other party assumed risk by not reviewing the contract. The statute of limitations might have expired, or the plaintiff may have been negligent in protecting themselves from deception. Courts carefully assess these defenses based on specific case circumstances. For victims who successfully prove fraud with convincing evidence, several types of recovery are available. These include damages for delay, compensation for embarrassment, humiliation, and mental anguish, loss of potential future earnings, attorney's fees, and in some cases, punitive damages. To prevent fraud in the factum, individuals and businesses should implement several legal safeguards. Ensure contract clarity by using plain language and providing ample time for review. Seek legal counsel to examine contracts before signing. Utilize secure signature methods like notarization or digital verification to prevent unauthorized changes. Most importantly, educate all signatories to ensure they fully understand the document's contents before signing. Fraud in the factum represents a serious breach of contractual integrity. Understanding the distinction between different types of fraud, recognizing the elements required to prove fraud, and knowing available remedies are essential for anyone engaged in contractual relationships. By implementing preventative measures and maintaining vigilance, individuals and businesses can protect themselves from becoming victims of this deceptive practice.